Good morning, good afternoon, good evening, depending on where you are in the world. Welcome to the second installment of the ACC Foundation and Lawyers Committee for Civil Rights Under Law webcast series, Supreme Court Review 2, UNC Harvard Affirmative Action Ruling and Pushback on Efforts to Quash DEI Measures. In this session, our panel will discuss how their companies are responding and continuing to prioritize advancing diversity and equity in their workplaces in the wake of the Supreme Court decision on affirmative action and the attacks on corporate diversity that have ensued in its aftermath. First, I'd like to thank the Lawyers Committee for Civil Rights Under Law for making this web series possible. We value this partnership and the amazing things that we're able to do together to advance diversity across the legal profession. Secondly, we'll have time for Q&A at the end, so please feel free to enter your questions in the Q&A module on your screen, and we'll field them as time permits at the end of the webinar. Also, feel free to engage in discussion in the chat. However, questions will be fielded from the Q&A module only. So without further ado, I'm pleased to introduce Damon Hewitt, President and Executive Director of the Lawyers Committee for Civil Rights Protection Under Law, who will lead our discussion today. Damon, the floor is yours.
Thanks so much, KJ. So glad to be with you all today, even under the sobering circumstances that we'll be discussing. Damon Hewitt, of course, from the Lawyers Committee for Civil Rights Under Law. I've been pleased and proud to be president of this organization for over 2 years now, and to come back to this organization after spending a summer here 25 years ago. This is a time when we need organizations like this and partnerships like the one we have with the ACC Foundation and this amazing leader, Jennifer Chin, and of course, the ACC itself through its leader, Vita Richardson, with whom I've been proud and honored to develop a great relationship. So what I want to do today is set a bit of context about what's going on, where we are, introduce the panelists, and then really get deep into the discussion. As KJ said, we will have time to answer questions. Before I continue, just a word about the Lawyers Committee. Our organization was founded 60 years ago at a meeting convened by President John F. Kennedy in the East Room of the White House. It was the same summer that Medgar Evers was assassinated in Mississippi. It was also the same summer that the March on Washington happened in DC as well. And within those fires of the civil rights movement, the president called together leading attorneys from the private bar, many people from law firms and in-house corporations, just like you. Over 240 lawyers came together to form what we now call the Lawyers Committee. 60 years later, we fight inside and outside the courts to ensure that Black people and other communities of color have the voice, the opportunity, and the power to make all of the great promises of our democracy real. We are about advancing racial equity and racial justice, and we believe that if we do that, we will help everyone in this country in doing so. So in terms of context, the headline to me for what we're discussing today is that we are in the most charted, uncharted waters you'll ever see. The most charted, uncharted waters you'll ever see. And as we get into the discussion, you'll understand quite why. Of course, earlier this year, the Supreme Court held that the college admissions policies at UNC Chapel Hill and Harvard College were unconstitutional. The court struck those plans down, and in doing so, we believe undermined opportunity in higher education. The Lawyers Committee, along with our co-counsel, litigated both of those cases for nearly 9 years and also argued the case on behalf of defendant interveners in the UNC case in the Supreme Court. It was a tough argument. Some people figured they knew exactly what would happen, but we fought hard to at least mitigate the harm and present the strongest case possible. Now, the decision did, of course, pare back the circumstances under which race can be considered in higher ed admissions. However, the court did not explicitly overrule precedent. In fact, at the Lawyers Committee, we say the court underruled the precedent by taking the same applicable precedent from Bakke in 1978 and Grutter in the early 2000s and twisting the logic and putting on steroids things like Justice O'Connor's note, which we believe was dicta, and the Grutter opinion about maybe affirmative action won't be needed 25 years from then, but we were deprived of at least several years, right? If that were even part of the holding. But the court did not hold that race can never be considered or never be at issue. In fact, there's a part of this majority opinion which held that nothing in the opinion suggests that universities cannot ask students to talk about their experiences with race in terms of discrimination, inspiration, or otherwise. We like to think that has a lot to do with the stories, the lived experience of our clients that we lifted up, a multiracial coalition of students at UNC and the Harvard students as well. Now, part of me has to say that it's not over yet in terms of race being a factor in any way, in part because we're litigating another case. Back in 2020, the same group that sued UNC and Harvard also sued, once again, the University of Texas at Austin. You may remember the Fisher 1 case from over a decade ago and the Fisher 2 case, which they said we'd all lose, and we did not lose those cases in the Supreme Court. Well, Ed Blum has sued under the banner of his organization that he created, Students for Fair Admissions, sued UT Austin back in 2020, but we are representing students as defender interveners there as well, and we expect that case to proceed. It was initially dismissed on race judicata grounds by the district court, but the Fifth Circuit revived it prior to the SFFA ruling, the Harvard-UNC case ruling. So there is more litigation happening there. Now, of course, that ruling, as we discussed in part 1 of this webinar back in early July, did not affect laws like Title VII, which governs discrimination in the employment context. It did not change Section 1981, 42 USC 1981, which governs the law of contracting, including employment-related contracts. So it didn't change those laws. So the same law is applicable, but some of those same laws are being used. The case, I like to say, changed nothing but everything. Nothing in terms of applicable law, but everything in terms of the political environment and the ferocity of the challenges. The fallout from the Supreme Court ruling has been swift and widespread. We cannot deny that. Even though the ruling only focused on college admissions, people like Ed Blum and Stephen Miller have weaponized it for rhetorical terms and also have tried to seek direct applications of the ruling in other contexts as well. Many opportunists have engaged in what we call interpretive overreach, misrepresenting the decision and trying to have a chilling effect on businesses, on workplaces, on government actors and decisions and stakeholders of all types, even on nonprofits who advance racial justice as part of their mission. We're seeing an uptick in lawsuits, which you'll hear about in a few minutes. What I want you to understand is that a number of these suits were filed before the Supreme Court ever ruled in this case, before the court even granted cert in the UNC and Harvard cases. So this is part of a continuum of attack. And frankly, we know that the attacks didn't begin with that case. The attacks did not begin with Gratz and Grutter. They didn't even begin with Bakke. Frankly, since there has been something that people call affirmative action, since there's been DEI, since there's been ESG, there have been attacks against it. What they're attacking is not the policy, but the progress. I honestly believe there are people who do not want to see certain communities advance because they want to retain power, control, and influence for themselves. That is honestly the way I view it. Now, at the Lawyers Committee, we have spent a significant amount of time helping various stakeholders, including in the corporate community, distinguish the higher ed context from their context, distinguish the applicable vectors and types of potential legal attacks, but also to strengthen the programs. As I believe my colleague Darielle will speak about in a bit, we've launched an effort at the Lawyers Committee called the Protecting and Advancing DEI Pro Bono Initiative. In short, we have rallied a number of leading law firms to work with us to provide confidential advice and, if needed, representation to smaller nonprofits, to public charities, and potentially even to small local municipal government entities who are trying to advance DEI and racial equity goals in a way that is on the spectrum of race consciousness. So we think it's really important to stand that effort up. I believe Darielle will speak more about it, and if not, I will as well. Finally, I'd say we have also urged the Biden administration to remain strong. As you hear, there have been attacks on government programs as well, as an effort to directly apply the UNC and Harvard decision. And so this is a time when we need not just all of government, as the president likes to say, but all of society, private sector, nonprofit sector, the independent sector, as they say, to stand up and stand together. So we're here today to listen, to learn, to share our experiences, our worries, and even our hopes and our ideas about how we can move forward. To engage in this conversation, we have an amazing panel, and I'll introduce them right now. First, my colleague, Darielle Rodriguez. She's the Deputy Chief Counsel at the Lawyers Committee, working alongside me and our Chief Counsel on a number of matters, advising us on providing strategic guidance on litigation and strategy in all of our projects to advance racial justice and equity. Darielle most recently served as the Deputy Chief of Staff in the Office of, as the Chief of Staff in the Office of Federal Contract Compliance Programs at the U.S. Department of Labor in the Biden administration. Prior to that, she led our Economic Justice Unit at the Lawyers Committee. Welcome, Darielle. Next, we have Danielle Conley. She is a partner at Latham & Watkins and a former Lawyers Committee board member. And she left that board only because a few years ago, she went into the White House counsel's office as deputy counsel to President Biden in that office of White House counsel. She advised the president, the vice president, and other senior White House officials on a wide array of legal issues related to voting, democracy, policing and criminal justice reform, reproductive rights, tech accountability, and judicial nominations, which has been a significant movement during your time there, Danielle. Thank you so much for that work. Danielle established and led the first ever White House Counsel Office team dedicated to civil rights and advancing racial, gender, and LGBTQ equity. She also served as a deputy on the Biden-Harris transition team's DOJ agency review team. Danielle's a good friend, and she's what I like to call counsel for the situation. Thank you so much, Danielle, for joining us. Next, Kim Cuccia is Senior Vice President and General Counsel and Corporate Secretary for NiSource Incorporated, a major utility company serving nearly 4 million natural gas and electric companies across 6 states under their Columbia Gas and NIPSCO brands. Kim provides leadership and oversight for all legal matters related to NiSource's gas and electric utility operating companies in its service area. She's been a member of NiSource's legal department for 14 years, so she's a veteran and she knows exactly what she's doing and what she's talking about. Prior to her current role, Kim was Vice President and Deputy General Counsel and Legal Regulatory Counsel for NiSource. Welcome, Kim. Thank you so much for joining us. And last but not least, Vicki Walcott-Edom is Vice President and Senior Managing Counsel for Global Employment Law at MasterCard. Vicki provides strategic and day-to-day practical employment law advice and offers creative solutions on a broad range of people-related matters to help MasterCard attract and retain top talent, people management. As a trusted advisor, she counsels clients and colleagues on an array of global and cross-border employment law issues, initiatives, and matters. Before joining MasterCard, Vicki was Senior Counsel for Employment Law with Macy's and Bloomingdale's. She began her legal career at Jones Day, where she worked in the firm's labor and employment practice group. Vicki, we're so glad you're able to join us today. Welcome. Okay, so let's get into the conversation. To get us started, we'll hear for a few minutes each from Danielle Conley and Darielle Rodriguez. Danielle, first, I'd like to invite you to discuss some of the various attacks on the workplace, DEI programs that we've been seeing in the wake of the Supreme Court ruling, and how you've been advising your clients. So just kind of give us a lay of the land as you've been seeing it, and then we'll turn to Darielle to talk a bit about what she's seeing and how you're moving. First, Danielle.
Yeah, great. Thanks very much, Damon. And really, I want to pick up where you left off, which was really talking about what the Supreme Court's decision didn't do, right? The decision really was limited to the use of race in college admissions decisions. It didn't extend to the employment context or to other diversity efforts more broadly. And in fact, and I think we mentioned this in the last forum that we did when the case first came out, the chair of the EEOC, Charlotte Burroughs, released a statement on the day of the decision, making clear that the decision, quote, does not address employer efforts to foster diverse and inclusive workforces or to engage the talents of all qualified workers, regardless of their background. It remains lawful for employers to implement diversity, equity, inclusion, and accessibility programs that seek to ensure workers of all backgrounds are afforded equal opportunity in the workplace. I think, Charlotte and others, sort of saw that ultimately folks would use pieces of the decision in a way that would attack diversity issues more broadly, despite the fact that the decision, again, really was limited to the unique context of college admissions decisions. Look, that said, I do think that the court's total rejection of the diversity interest underpinning race-conscious admissions has and will continue to give ammunition, right, to staunch opponents of diversity efforts much more broadly, including race-conscious and other diversity-related efforts by companies. So, for example, we've already seen letters to CEOs from Republican attorneys general, letters from conservatives on the Hill, as well as anti-affirmative action and anti-diversity advocacy groups who have cherry-picked pieces of the court's decision to support the sort of sweeping notion that DEI efforts are, unconstitutional or otherwise illegal and violate the civil rights laws. And so, just to break that down a little bit, right after the decision, the attorneys general of 13 states wrote to all Fortune 100 CEOs to, quote, remind them of their obligations as an employer under federal and state law to refrain from discriminating on the basis of race, whether under the label of diversity, equity, and inclusion or otherwise. And then a couple of months later, Senator Tom Cotton sent letters to 51 law firms detailing the possible federal civil rights laws that he believed that the firms and potentially even their clients could be violating with diversity, equity, and inclusion programs. Shortly after that, we had the attorneys general of 5 states write to the leaders of the top 100 law firms with a very similar warning about the firm's diversity, equity, and inclusion initiatives. On top of that, sort of the letters from the state AGs and from folks on the Hill, we've also seen a really significant uptick in EEOC complaints that challenge company DEI policies and initiatives, including things like diversity hiring targets and goals. So America First Legal, which was founded by President Trump's former senior advisor, Stephen Miller, it really is leading the charge on that front and has filed EEOC complaints against Starbucks, Morgan Stanley, McDonald's, and most recently, I think it was last week, Salesforce, for alleged racial and sometimes gender discrimination based on these companies' recruiting and hiring programs and goals. I think it's helpful to highlight some of the arguments they're making in these EEOC complaints, and in looking at the one that was filed regarding Salesforce just a week or so ago, they pointed to the fact that Salesforce had published data about their year-over-year increases in women and Latinx and Black workers, and pointed to that increase as, quote, evidence of successful discrimination. And in that letter, they also attacked the legality of affinity groups and employee resource groups, stating that, quote, to help Salesforce achieve its desired sex and race balance, the company has created these equality groups, and noted that tellingly, there are no comparable programs for white or male employees. And so again, pointing to this idea of Black community groups in the workplace or, women community groups in the workplace as evidence of discrimination, which, well, we can get into sort of the details of the law, but certainly the Supreme Court's decision did not go that far. And there's been no court decisions that under Title VII or Section 1981 that something like a affinity group in the workplace, violates any of the civil rights laws. In addition to those EEOC complaints, we've seen several recent lawsuits that have been targeted at corporate DEI initiatives. And Damon, as you flagged, some of those cases were filed well before the Supreme Court's decision in the SFFA case, but many of them were filed after. And I think it's a place where we're going to see a continued uptick in litigation. And so just a few examples there. Pfizer was sued last year for its Breakthrough Fellowship Program, which provides employment and scholarship opportunities to applicants who met the program's goals of increasing the pipeline for Black, Latino, and Native American scientists. And that case is currently pending before the Second Circuit. Notably, Pfizer ultimately sort of changed some of the eligibility requirements of its program in order to deal with this issue. And at the same time, we saw recently 2 lawsuits filed against law firms, Perkins Coie and Morrison and Forrester, for their diversity fellowships, which provided stipends and summer internships and mentorship programs for first and second year law students. And again, those programs were sort of designed to increase the pipeline of students who had been historically underrepresented in the law, like African American, Latino populations. Both of those cases were brought by the American Alliance for Equal Rights, which is also an Edward Blum stood up group, just like Students for Fair Admissions was, sort of with the sole purpose of challenging these race conscious efforts. The things that I'll note about the law firm cases, and both of these are recent developments, is that both cases have now been dismissed. The case against Morrison and Forrester, I believe, was dismissed a week or so ago after they changed the language to make clear that their fellowship is open for all. And similarly, just yesterday, Perkins Coie, AAER, the American Alliance for Equal Rights, filed a joint stipulation for dismissal after Perkins agreed that membership in a group historically underrepresented in the legal provision or profession is not required in the new fellowship program that they're instituting, and that race won't be one of the factors that will be considered for program eligibility. And so, we are seeing, again, sort of recent cases, recent EEOC complaints, recent letters from political bodies that really do suggest a growing appetite to challenge diversity, equity, and inclusion programs, again, under this notion that anything that's race conscious violates what the Supreme Court ultimately held in the university admissions cases. But I'll say at the same time, there's also significant support for these programs in the legal community, as evidenced by the robust defense of some of the above diversity programs, including through things like amicus support in cases like the Fearless Fund litigation, which I know that Darielle will talk about. And I think, one of the things that you're going to hear us talk about sort of throughout this discussion is that, one of the things that I think is really important when looking at and evaluating the legal landscape is that companies, and the advice that I've been giving my clients is companies shouldn't be overcorrecting in the wake of this decision by, for example, scrapping all of their DEI programs and all of the diversity initiatives that they have, because again, that's not what the Supreme Court held in the SFFA case, and there's no decision on the merits in any of these cases that suggests that a broad overcorrection like that is necessary. But I do think that every company needs to do an assessment of their current programs to ensure that they're on the right side of the legal lines. And that's not because the law in this area has changed, but because DEI is now in a very target-rich environment for litigation. And so you want to make sure that the programs that you have are legally sustainable while still effectuating your goals. And so, I think for organizations that have diversity programs, fellowship programs, other sorts of DEI sponsorship and mentorship programs, really working with your in-house legal teams, if you needed outside counsel, and your HR and DEI teams to say, what are our goals in this space? And how do we make sure that those goals are legally durable? Like, based on what's been happening, how do we make sure that we're doing this in a way that if we do get sued, we've got viable defenses here and our programs can withstand these current attacks? But I don't think that means to scrap everything altogether. It just means being very smart about what you're designing and how you're implementing those programs.
Danielle, that's a wealth of information and analysis. And I love the way you ended it. I like to say that not being sued is not indicative of success, because you could avoid liability or a negative ruling and have a program that does not advance your stated goals whatsoever. At the same time, being subjected to suit or receiving a threat letter doesn't inherently mean you're doing something wrong. It might actually mean you're doing something right. Now, I know that's a really tough risk calculus for in-house counsel and outside counsel to hear, but we think that's true. Let me transition to Darielle. Darielle, Danielle spoke a bit about making sure the programs are defensible and also strong. I hope you can share a bit about the protecting and advancing DEI pro bono effort we've launched at the Lawyers Committee, but then also come back and talk about what you're seeing in terms of some of the attacks and responses there too outside of the workplace.
Sure. Thanks, Damon, and thanks, Danielle. And I wanted to provide a little bit of context to the information that Danielle shared about these most recent attacks. Of course, the SFFA ruling has provided ammunition to opponents of civil rights to attack these programs in different sectors. But these attacks began even before the SFFA ruling. We all remember in 2020 when George Floyd was murdered, that there was a very strong response, I think an unprecedented response by the corporate community to really commit efforts to advancing racial equity. And that was really the result of the BLM movement, which really shone a spotlight on systemic racism, including in economic opportunities, including in the workplace. And there's some recent research. There was an article in the Bloomberg law journal showing that there were positive results as a result of the BLM movement that happened during the pandemic. They analyzed EEO-1 reports that were filed by Fortune 100 companies. And what their research showed was that there were actually increases in terms of the hiring of Black workers and other workers of color across different levels, showing that when there is pressure put on companies to ensure that they are making progress in terms of hiring Black workers and other workers of color, they actually get it done. You know, I think one thing that we oftentimes hear is that companies say that they struggle with a pipeline issue to identify talented workers of color to fill positions. Well, I think this data shows that when companies are really focused on advancing racial equity, they are able to make some progress. And not surprisingly, when there is some progress being made, we're seeing a backlash. And at the Lawyers Committee, we recognize that the risk calculus has changed because of the SFFA ruling. We also know that systemic racism continues to exist and that racial equity initiatives continue to be critically important, and that companies must continue to keep their foot on the pedal and to continue advancing these very important priorities. We cannot afford to lose the progress, quite frankly, because the economic well-being of the communities that we serve depends on those initiatives. And quite frankly, our country depends on many of these initiatives. So at the Lawyers Committee, we're really engaged in a multi-pronged approach. We, I think, are best known for our impact litigation work across different areas, across different programmatic areas, including education, fair housing, employment. But we're recognizing in this moment, we really have to deploy an interdisciplinary, multi-pronged approach to ensure that we are responding effectively to these various attacks. And so what that means is we're coupling our impact litigation with outreach and education. We're spending a lot of time speaking to various groups, different stakeholders about the backlash that's occurring and how entities can really remain on course and continue to move forward with their very important initiatives. We're also engaged in the pro bono initiative that Damon mentioned, where we are providing advice and counsel to eligible entities that would otherwise not be able to afford private counsel on their questions and issues related to their existing racial equity initiatives. And that is an initiative that is underway. We are starting to receive intakes, and we're very excited to be engaged in that work with our anchor law firms. So now turning to the other cases that are cropping up in other sectors beyond employment. I guess I wanted to start with the Fearless Fund case, because this is a case that the Lawyers Committee weighed in by way of an amicus brief. The Fearless Fund case was brought by the American Alliance for Equal Rights, and they sued Fearless Fund, which is a venture capital fund, alleging that its grants programs, which award $20,000 grants to startups run by Black women, were racially discriminatory in violation of Section 1981. In that complaint, they cited SFFA in the first paragraph, even though, as Danielle and Damon have mentioned, the SFFA case dealt with Title VI, the Equal Protection Clause, and not Section 1981. And at the district court level, we did get a positive ruling. The district court held that the plaintiff was unlikely to succeed in their preliminary injunction motion, and that ruling was based on First Amendment grounds. The court held that Fearless Fund was engaged in speech by advancing its mission rather of supporting Black women business owners, since they are historically underrepresented in the venture capital field and in terms of the funding that they received, and that there's really a need to invest in Black women business owners specifically. Plaintiffs immediately filed an appeal, and the circuit court granted an injunction while the appeal of the merits of the PI are heard. So that's where the case is. We led one of the amicus briefs that was filed in that case. We filed that brief on behalf of 6 civil rights organizations, a very strong coalition of civil rights and racial justice groups. And our amicus brief focused on the history of Section 1981, which was actualized after the 13th Amendment's abolition of slavery. The congressional intent of passing Section 1981 was to ensure that newly freed slaves had the freedom to engage in contracting activities free from discrimination. So in our amicus brief, we argued that it was quite ironic that Section 1981 was being used to challenge this remedial program designed to increase economic opportunities for Black women business owners, and that prohibiting that type of business owners to engage in the freedom of contracting. In the shareholder space, I know that some of my colleagues on the call will discuss the shareholder activity later on in the panel, but there was a recent ruling by a Washington federal judge against a conservative think tank's investor suit challenging Starbucks diversity policies. And that ruling was issued in a blistering opinion. The name of the think tank is National Center for Public Policy Research. And what the court held was that they were improperly trying to advance their own ideological goals through this shareholder derivative lawsuit, seeking the court order to invalidate the company's DEI initiatives. Then in the contracting space, there are a couple of cases, but I want to highlight the most recent ruling in the Ultima case, which was brought by a small women-owned business, which sued the USDA and the Small Business Administration, arguing that by relying on a rebuttable presumption that people of certain racial and ethnic groups are socially disadvantaged, rather, that the SBA and USDA were violating the Equal Protection Clause in awarding those grants. And the court agreed with that woman business owner. Back in July, the court granted summary judgment for plaintiffs, relying actually on SFFA to find that the rebuttable presumption used by USDA and SBA was not narrowly tailored to compelling government interests. And so now the plaintiffs have filed a motion for a permanent injunction. So that is just kind of a brief overview of some of the cases outside of the employment context. And we are seeing these attacks in multiple sectors, but as you can see, there are mixed results. And I think we just need to continue monitoring, because a lot of the law in these cases, these are novel issues that are going up to the courts. And we just we have to continue to monitor them very closely to see how these rulings come down.
Well, thank you, Darielle. It all sounds very sobering, but I'm hoping to get some real talk, additional real talk, and level setting from our in-house counsel friends, Kimberly, and Vicky. So before I get into very specific questions, I want to just turn to you, Kim and Vicky, in that order, to take the floor to give us kind of a broad overview of how corporations and in-house legal departments are responding to all the things that are swirling with such ferocity right now.
Yeah, thanks, Damon. And I just want to start out by saying I am so incredibly pleased to be participating on this panel with such esteemed colleagues here in the legal profession and thought leaders in this space. I will also disclose that I'm recovering from some kind of bug, so if I have to pause for a moment and grab a drink, I do apologize in advance. I think, from an in-house perspective, our response is largely driven by the posture of your C-suite in a way. What are your organization's values? What is your risk tolerance? Nothing comes without risk here. It's on a spectrum. The SFFA decision and even the lower court cases following that decision do not require us to halt diversity advancing initiatives. And you have companies that are taking highly conservative measures, and that's comfortable for them. You also have companies that are pushing more towards the limit, and that is comfortable for them. And, you know, a couple of examples to sort of help put this in perspective, I was trying to think of like how to actually materialize and give some concrete examples. One is around talent programs. Some organizations are changing their eligibility criteria, similar to the law firm cases, to be open to all. Historically, targeted diverse programs are now, they're opening the eligibility to everybody. Other organizations and other companies are continuing talent programs that are targeted to historically underrepresented individuals because they're considering those programs a part of an overall suite of offerings that together provide equal opportunities for all, and they're prepared to make that case if needed. They're willing to take on, you know, some potentially assumed risk in that space. So I think about from an organization's perspective and from an in-house perspective, the act here for in-house counsel is to understand the facts and the circumstances of your organization, where your leadership team is willing to go, but making sure that they're advised all along the way. The other one that I wanted to mention is around supplier initiatives. For example, I will say that, you know, my organization at NiceHorse, we've been particularly vocal historically about our diverse supplier program. And it is designed to specifically grow in general a supplier pool that is available to us. And we've not been shy about expanding our supplier recruiting efforts to avail ourselves to all qualified contractors to be able to do our work. And we want to let it be known to the world that we are very much willing to do business with diverse contractors along with any other contractor. So how we make ourselves aware and how we inform ourselves, I think it's how you go about doing those things that we need to be careful in looking at. And it's about not setting and being very mindful, I would say, of quotas, right, versus having goals. My personal view is knowing your numbers, understanding your metrics, and frankly, setting goals is not, that's my personal view, is not illegal. It's how you carry those things out in terms of goal setting and how you advance them that need to be particularly and very carefully considered. But the service that we all need to do for ourselves is being educated, and that is something that we're discussing in great detail in my organization.
Thank you so much. I'm going to resist the urge to ask a follow-up now because I have a couple, but I'll turn to Vicky to give what you're seeing in the lay of the land.
Sure. Thank you, Damon. And again, similar to what Kim said, it's a pleasure and real privilege to be here and spending time, with everyone today on this very important issue. And when I think about, these issues as well, I think one of the things that companies are thinking about, including ours, is when you ground yourself in the purpose. You think about, why are we here? What are we trying to accomplish? And that's really important because sometimes when you hear some of the critiques that come out, in discussion, general, it almost sounds like DEI initiatives can be gratuitous or, platitudes and just being done for sake of doing them. When you really think back of the history and you think about Title VII, for example, and even the context in which the Title VII was enacted, 1964, the heart of the civil rights movement. So, DEI initiatives by themselves or in and of themselves were born out of a recognition by the government that there were inequities and that private employers should be focused on making sure that there are equal opportunities under law without regard to race, ethnicity, and gender. So that's where, sort of we start from, as a society, and the government recognized that. An additional layer, with respect to even the government, thinking about OFCCP. And if you have a company that is a government contractor, there are obligations there as well to take and make good faith efforts to diversify one's workforce, always picking the most qualified person without regard, but making those efforts. So I think that's just an important starting point. And when you look at the history of why we're even having these conversations and where DEI efforts sort of were, born from and why there's a need. And I think what companies are generally saying is we recognize that there's this history and want to be part of the solution and want to be part of the solution and moving things forward and doing the right thing in that regard. So I think that's important. The other thing, and I'll just echo what Kim said a bit, and I think of it as know thyself. I think we talk about a lot of, and probably talk a little bit about that, different initiatives. And Danielle talked about sort of an assessment or an inventory of current programs and initiatives. But I don't think it can be overstated, at least from the in-house perspective, to really understand the organization. And Kim, you talked about this, with the C-suite, but understanding the organization, understanding your workforce, understanding the geography, what types of roles do you have? What's going to resonate from within? Do you understand your employee population? Because you can have a suite of offerings, you can have a suite of products and projects or deliverables, but if they won't be effective or well received within the organization, then to some extent it can be busy work. So I think that's incredibly important. When you think about diverse slates, for example, something a little bit more concrete, that might work very well for organization A because organization A is focusing on hiring and perhaps they looked at the data and can tell. And that's also knowledge is power, looking at the data to see that there may be a hiring issue and maybe there's a gap to close there. Perhaps organization B, perhaps hiring is not necessarily where it is, perhaps it's retention. So I think that's also important from the in-house and corporate perspective, is really understanding your organization deeply and knowing your data so that when you're designing programs and you're thinking about the newer criticism that's coming up, you're being effective. Also, from the perspective of MasterCard, I think just speaking for the commitment to DEI, that's something that has been longstanding and is not new. And just similar to what others have said in terms of the law hasn't changed, but perhaps the scrutiny has. So that just means that doesn't mean that the work has to stop. It doesn't mean the objectives have to stop, but there can be pause. And when you get new information, you can take that in, consider, sort of and tweak and think about things in a little bit, of a different way. The other thing I was just going to add is, this is an opportunity. I think this could be an opportunity to also think about things a little differently, even though the law hasn't changed, but perhaps there are opportunities to get different perspectives. And when you're thinking about it from a corporate perspective, thinking about the stakeholders and perspectives that, companies and others are seeking, making sure you're making good use of your colleagues within the legislative and public affairs teams and finding out if you can get insights on what matters in the different state and local legislatures. That can be helpful. Leveraging, in-house or litigation teams, our external legal partners. And this really does, I think, take a concerted effort. And just thinking about even change management. Do you have the skills within your team? How do you communicate more effectively? Perhaps there are things to clarify in messaging, making sure that your employees are hearing the message that you're sending as intended. So I think being very intentional and strategic here and being very organized also is incredibly important.
Thanks so much, Vicki. I love the know thyself because it reminds me of our advice to higher ed institutions about being mission driven. Understand your why. Do you have the type of program that is really curing for something that's a deeper issue or trying to cure for it? Because the truth is no DEI program can fully cure for the deeper issues. They can help, they can be a part of a solution. I love also the notion that DEI really is your floor, not your ceiling, on what you could or should be doing as a company, taking a hard look at the things that matter, not just the atmospherics, but also the business model itself of how you get your business done. How do you get that business done in a righteous way? So really important questions. And Kim, I'm going to come back to something you said about know your numbers. And I actually have a question that I'm actually going to pose initially to Darielle and Danielle. As litigators, we all understand that we think of risk in a different way, not risk for launching an initiative, but once you're in litigation, what's discoverable and what will be manipulated in discovery. And I wonder if you have any thoughts about or advice to in-house counsel about knowing your numbers. I think about how this came up in the context, I think it was the Harvard argument, not the UNC argument, about were the admissions professionals constantly looking to see, did you have enough Black and brown students? What might be your initial top of mind advice for in-house counsel on knowing your numbers?
Arielle, I'm happy to kick us off on that. So look, I don't think that there's certainly not anything that's per se illegal about knowing your numbers and about looking at and evaluating sort of the demographic data. And in fact, to the extent that you're going to, sort of figure out where you might need programs to help support the retention of women or people of color in your organization, I don't know how you do that without sort of understanding what your demographic data is, right? And so the real question is, are the people in your organization educated with respect to what they can and cannot do with those numbers, right? And under Title VII, you can't, use race or gender to put a thumb on the scale when making a decision when it comes to hiring or promotion or termination. Hiring and promotion, we can talk about whether you've got a valid affirmative action program. That's the only sort of slight exception. But just as a general premise, you can't use race, you can't use gender when making those employment related decisions, right? And so if what you're using the data for is, hey, we're really having trouble at a certain level retaining, women. They seem to drop off after they're, after spending 3 years in this particular business unit, or, we're really having trouble getting people of color in these sorts of leadership positions. You can target programs that are aimed at increasing the pipeline, that are aimed at increasing the support for those populations in a way that's targeted. You just need to make sure that your people in your organization, your HR teams who are making employment-based decisions, understand that those numbers can't be used as a guide to say, okay, now we're going to hire 3 more Black people because look, we're down, right? That's where the violations of the law, and again, we can talk about affirmative action programs, that's sort of separate, but it really is what you do with those numbers. And I think a part of it goes back to Kim's point about risk tolerance, right? For organizations that are extremely, extremely risk adverse, they may make a decision that people in their HR function should never get access to sort of the demographics because they don't even want to run the risk of people making those kinds of decisions. Whereas others, again, if they've got sort of a value system that is, we want to ensure that people of color and women continue to sort of grow and thrive in our organization. And in order to do that, we need to be able to assess how we're doing. Again, there's nothing illegal about that principle per se. It's just what you do with it.
Thanks. Darrell, anything you wish to add?
I agree with everything that Danielle said, and just that I've seen how powerful data can be for businesses. Vicki mentioned federal contractors with affirmative action obligations, and at the start of my career, I spent a good chunk of time representing federal contractors before OFCCP and audits and helping them prepare their affirmative action programs. And I guess the only thing I'd like to add is that data can be very useful, not just in assessing the workforce representation of underrepresented groups and comparing that with the availability, but also to potentially identify policies that are neutral, but that are having a disproportionate negative impact on underrepresented groups, right? Things like, are you screening out applicants because they have employment gaps in their resume? A policy like that may have a disproportionate impact on caretakers who may be, more likely to be women than not. And so data can be a very powerful tool in identifying neutral policies that are disproportionately keeping out talented workers from underrepresented groups from getting good jobs. The other thing too that I think is very helpful to do, but I think sometimes companies are less focused on this, is just tracking the results of your recruitment efforts, right? If you do an analysis and you realize that you have an underrepresentation of, let's say, Black workers in a particular category, lower than what you would expect it to be given your availability, and you want to change your recruitment practices in that space to more effectively recruit talented workers, Black workers and workers of color, I think it's really necessary to just check the progress of your recruitment efforts to see if they are really resulting in more candidates, more diverse talent applying for your jobs, as opposed to just, undertaking those efforts for the sake of undertaking them and then not really monitoring them to see if they're moving the needle.
Thank you. Okay, so I'm going to ask a couple of other questions now, and you'll have to forgive me because I gave you a sense of some of what we'd ask, but you're inspiring me to ask further questions. So Kim and Darrell, you both referenced obligations of federal contractors. Just help the audience understand how you distinguish those obligations from the types of more general DEI efforts that may be attacked. Because the federal contract obligations are a requirement under federal law. So it's help make sure everyone understands the distinction between that context and the context in which an employer is not a federal contractor and is not acting pursuant to those obligations.
Just quickly, businesses with federal contracts that meet a certain monetary threshold have heightened obligations under Executive Order 11246. And that includes if they meet certain employee thresholds, they have to prepare written affirmative action programs or plans. And basically what those plans require companies to do is to conduct pretty thorough internal self-analyses to identify where there may be barriers in equal employment opportunity in hiring, in promotions, terminations, and compensation. And businesses are required, federal contractors are required to do that sort of self-analysis on a regular basis and to track their progress in addressing the barriers that they identify. So it's just, it's the obligation that federal contractors have, since they are receiving federal monies, to ensure that their processes are not discriminatory and that they are undertaking affirmative, and it's kind of a misnomer, affirmative action, because I think when people hear affirmative action, they're thinking, oh, quotas or making decisions on the basis of protected categories. And that is not what affirmative action means under Executive Order 11246. It more so means undertaking a heightened responsibility to ensure that there aren't artificial barriers to EEO in your policies and procedures.
Got it. Kim, anything you want to add to that or no? Not necessarily, but.
Nope, I was speaking more generally, general contractors and general supplier sort of initiatives, Damon. So nope, I defer to Darrell. I thought she covered it well.
So let me pitch this to you just for everyone. We've heard earlier in the presentation that employers may still pursue DEI goals in hiring. And are you able to say definitively, Kim, that employers can also pursue diversity goals in their outside vendors and supply chain?
I personally believe the answer to that is absolutely. Just for the the exact same reasons that Danielle sort of covered and Darrell covered, which is knowing your demographics, knowing the demographics that are available out there sourcing. I think knowing what your numbers are and understanding that there's maybe a lot more supply than you think that there is, and just being informed. So no, I don't think that there's anything wrong with setting goals, understanding how you're showing up, and understanding whether or not, frankly, you're being inclusive to the opportunities and the sourcing contracts that are out there.
Right. Yeah, I think that's I'm sorry, does someone else want to weigh in?
No, Damon, I just wanted to go back to sort of one thing about diversity hiring goals that I think is really important, because a lot of the challenges that we're seeing in the EEOC complaints that I mentioned at the front target things like companies having these diversity hiring goals. For example, if they say, we as an organization want to reach 30% women by 2025, or 30% people of color by 2025, and are attacking those goals as sort of being per se, violations of Title VII and Section 1981 and the other federal civil rights laws that we've gone over. And the thing that I want to mention there is I do think diversity hiring goals like that can be tricky, for the reason that I flagged, that you got to make sure that your people understand that those goals are aspirational goals, and that they, again, can't sort of put their thumb on the scale in a way that would violate Title VII in order to reach those goals. And so I think as long as we're sort of like clear with folks that like, yes, you can have these aspirational goals, but like at the end of the day, there's still certain things that you can and cannot do under Title VII and under Section 1981. And we would have given you that advice 5 years ago. It has nothing to do with the Supreme Court's decision, right? And so, you know, when you have goals like that, you've got the training of your HR function and of your people who are making these decisions. Like, you've got a problem, you know, if they are thinking, oh, well, we've got a goal of getting to 30% people of color by 2025. So that means that I can put my thumb on the scale for race. That's where the problem comes into play.
And Danielle, would you say, I mean, my view is sort of some of the discussions we've had is that it does become more risky when you even introduce numbers. So quantitatively versus qualitatively, because it is harder to make at times a quantitative goal aspirational, or to convince
1000%.
when you're looking at a record that it is aspirational. It doesn't mean you can't do it, but I thank you for following up and sort of confirming some of those things around it, because I think it's the why behind what it is that you're trying to achieve and really helping people, particularly all employees, depending on how broad reaching your goals might be, reducing any perception of unfairness, right? And I think that's really key.
Absolutely.
Right. Nice. Well, look, I would cite a notable example of goals. American Express, whom the Lawyers Committee honored at our annual Elian Higginbotham Leadership Awards last year. We honored them not just because they do DEI, but because they made a $1 billion play to promote diversity and access and racial equity across the spectrum. As part of their broader ESG strategy, they established long-term goals and objectives across 3 critical areas for their company, their stakeholders, and society: promoting diversity, equity, and inclusion, and that is internal and supply chain, advancing climate solutions as part of their ESG work, and also building financial confidence and capacity, direct investments in communities of color for organizations that advanced those interests. And I cite them because they're very public about it. It's probably an SEC report somewhere, is filing somewhere as well, as goals. I also think, and I think that you all gave really wonderful and thoughtful responses. And what I'm about to say, I don't wish to complicate things, but I'm going to note a bit of I won't call it a tension, but an oddity. In the equal protection context, in the higher ed affirmative action cases, and then also, I think this came up in the ultimate case as well, the SBA Section 8A case, this notion of, well, in order to ensure that a program is narrowly tailored under the 2-pronged analysis of compelling interest and narrow tailoring, the courts want to see that there are measurable, articulable goals. That stands in a bit of tension with the other notion that courts have talked about, which is flexibility, if the program is too inflexible. So it's really, this is why I think the underruling concept that we've been talking about, the Lawyers Committee, is really apropos, because it's almost like a logic trap, a box that you get put in. And so I think you all have given some very strong and practical advice about kind of know thyself, know your numbers, but also be thoughtful and precise about how the numbers are utilized and leveraged internally. So lots of tough things. I think the most important takeaway for me is that bright lines are elusive, except at the margins, but everything is context specific, which is why you better get yourself great counsel. And there's a few on this call who can, I'm sure, support those needs. Before we move on to, please, Vicki, go ahead.
Just wanted to add just something, and just thinking about, diversity and equity and inclusion programs, and just picking up on something that, Darrell was talking about in terms of neutral policies. But also, I think it's important when you think about DEI programs, thinking broadly. So even thinking about one's benefits or a company's benefits. So for example, thinking about a family building, program, and that's something that MasterCard offers, where there's certain reimbursements for certain medical expenses related to fertility or surrogacy or adoption or things like that. And that's something too, that it's a neutral policy, but it also can help to support families, and perhaps, women are delaying child, rearing for a longer period of time, perhaps, and those services are necessary, or for same-sex couples or things like that. So I think it's also important to think about DEI initiatives in terms of back to the values and supporting and being inclusive, thinking outside the box, and not just necessarily sticking to some of the same, typical programs, which are perfectly fine, but also being, creative and thinking about how you just are able to provide support for a broader employee workforce, going back to the point of knowing thyself and knowing your workforce.
Thank you. I'm going to turn to Darielle to pose some of the next few questions. Darielle?
Sure, thank you. So I'm going to share a couple of questions that we had received in the first panel that I think may be of interest to our participants today. And one question, and I'll pose this to Kim and Vicky. In the current legal and political environment, how can we hold managers accountable for their actions in terms of advancing DEI goals? And I mean goals sort of in the broader sense, right? If you have a DEI strategy and you're looking to accomplish certain goals related to that strategy, how can we just hold managers accountable for undertaking and that progress and moving the needle?
So I can start with that. And first, I guess when I think of your question, I think about, goes back to the organization and back to what are the organization's goals? What are the organization's objectives and initiatives in that sense? And are managers even aware of them? So it's I think really incumbent on an organization to be able to communicate that effectively and also be specific in terms of what it is exactly you're asking for a manager to do. Are you, again, focusing on hiring, and is it diverse slates? Are you talking about being inclusive? Is it communication? And I think, Danielle, you made this point, I think, very well, but making sure that you understand what is being expected and understanding what the issues are. Because if a manager is on the front line and they should know, do they need to know about the programs and benefits? How can they speak to it? Are we talking with the same language? And that's something that you also mentioned, Darielle, in terms of things being a misnomer and understanding the baseline, because what may mean, what someone might think that affirmative action means one thing, someone else might think of it in a totally different concept. And it's difficult to hold, I think, people or managers accountable if they're not clear. And I think you've got to get specific, and then also getting the buy-in. And once you've communicated the expectations, you've been specific about it, and then you have the buy-in, then I think companies are in a position to be able to have conversations with managers, hold them accountable. And also, I think it's important for managers to know that there's support, and are there experts within the company whom they can consult and go to, and helping in that regard as well.
I agree with everything that Vicky said. And from my perspective, leadership is key. How we hold people accountable in how we talk about our goals and the tools that we use to advance them. And why a certain, and we need to be clear, as I mentioned a little bit earlier, as to potentially why certain decisions may be made to help reduce misperceptions. So it's not breaking news that Title VII remains unchanged. The standard remains unchanged. And I think Vicky said it earlier, it's the level of scrutiny that has changed. So it's the how. And from my perspective, it's recruiting, it's considering diverse slates of candidates, and that you have a robust sourcing strategy. It's focusing on the retention of current employees and the types of benefits and services that you offer them, and creating an inclusive environment where everyone is welcome, right? Recommitting to best practices. So you may have a diverse slate, post SFFA decision and new case law that follows. Double down on your best practices about how are you documenting employment decisions, hiring decisions, firing decisions, promotion decisions, to document legitimate non-discriminatory reasons that choices are made. So I think it's being informed as to what the rules are, and what we very much need to understand is that the rules are a little bit in flux at the moment. So a very close partnership with HR and legal and your business partners and just being able to be a little bit more nimble, having active conversations, I think is really, really important right now, and making sure that your business partners know what the tone at the top is, what are your corporate goals, what is the sort of the direction and the commitment in terms of advancing diversity, what can they do, what can they not do, and who do they go to ask a question, I think is really, really important. And I'm emphasizing a little bit of what Vicky already said.
That's great. Those are both really practical answers. We received a couple of questions in the chat. I think I'm going to try to combine a couple into one question. And Danielle, if you feel comfortable, I'd love for you to share your thoughts in response to these. But basically, the two questions are kind of in the vein of, we've said on this panel repeatedly that the SCOTUS ruling was focused on higher education admissions. In light of that, though, we're seeing recent news reports that the two law firms who were sued have changed the requirements of their DEI internships to settle with Blum, who had sued them. What do we make of that? And then also, given that the Harvard UNC ruling is limited to higher education, how do we frame corporate DEI programs so that they are viewed as being constitutionally lawful?
So I'll start with first, Arielle, with the caveat that I don't know the ins and outs of the two law firm programs and don't want to speak about whether they violated the law before or anything like that. But what I can say is that as a general matter, and I think this goes back to thinking through things like risk tolerance and how much risk are you willing to take on, and are there ways for you to effectuate your goals that are less legally risky? And so I think when you're talking about programs that potentially have a contractual relationship, so it's an employment-based relationship, or it's a scholarship or a fellowship program where an organization is onboarding someone or saying, I'll give you this if you give me X. If you're in a contract-based world, then you need to be thinking about Section 1981, right, which prohibits sort of the use of race in contractual relationships. Again, there might be limited exceptions if you've got a valid affirmative action program, but even that is legally risky. And so I think when you're thinking about certain programs where you've got those sort of contractual based relationships, it's really helpful as an organization if you think about, well, do we actually have to limit this pipeline program on the basis of race? Or can we meet our goals by looking at race neutral factors like, opening this up to first generation college students, or, kids from a low socioeconomic status, or from certain school districts, or like, what are the other kinds of things that we could do to really sort of target a population of folks that have been historically shut out, that are underrepresented, in our particular industry? And if you can do that without the use of race, then and you're talking about a contractual relationship, then like you should do that based on sort of the plain reading of 1981 and the recent challenges that we've seen. And so I think that again has nothing to do with the Supreme Court's case, but it does have to do with the fact that more of these lawsuits are being brought in the wake of the Supreme Court's decision. But the Supreme Court's decision wasn't about 1981 at all. It's just that these kinds of programs are more likely to be challenged just in light of the sort of legal environment that we're in right now. And so I think that dovetails, Darrell, right to your next question about how we sort of think about corporate DEI programs and like how to make them, it's not really a constitutional issue in most cases, but how to make them sort of survive legal challenges. And I think, again, that's thinking about the people who are implementing those programs, making the HR folks, the DEI folks, making sure they're super tight with the lawyers in-house and outside counsel when needed, to make sure that you're staying on the right side of the legal line. So if you've got aspirational goals of increasing the representation of women or people of color in your organization, making sure that HR and the DEI teams understand that, like, thinking of recruitment and retention efforts and pipeline efforts as opposed to decision-making on the basis of race and hiring and promotion decisions is the way to achieve those goals legally. That really is the key.
And I just one thought to add to that is that oftentimes it takes a while to see change, right? Change doesn't always happen overnight. And so when you're undertaking, for example, different recruitment strategies, it may take time before you really start to see the fruits of those efforts. There was another question about challenges and tips for obtaining, collecting, and using DEI data from an organization's workforce, especially for multinational companies that have employees in various parts of the world. Vicky, I don't know if you could speak to that.
Sure, I can take that. And I think, so the last part of that question in terms of different parts of the world is probably the key. When you think about, using data just generally, you certainly have to be most sensitive and attuned to the laws in those jurisdictions because they vary. If you look at Europe, for example, you have the GDPR, and you have to be very, careful about data and get consents, and you really need to be knowledgeable about that. And even within Europe, certain countries may be more permissive than others. The other thing to think about, there are cultural norms too that need to be taken into account in terms of what's appropriate, what's acceptable, and what's being sensitive. So if you think about a situation where perhaps you're thinking about a global company, there are some countries where being gay is illegal and criminal. So you have to make sure that as a global organization, you're synthesizing that and sensitive to that, so that one well-intentioned program doesn't inadvertently put employees, for example, in harm's way, because that's never the intent. I think also tip, have a good global counsel. So this way you can have that sort of mosaic and to help you so you don't have sort of a, patchwork of, sort of solutions and things like that.
That's great. That's super helpful. I think we probably have time for one more question. I don't see any cues from the moderators. So I'll pose one last question, and I'll pose this to the three of you. And then I think we could probably wrap up. But in terms of employees, right? How much should companies share with employees? How much should they bring them into decision-making related to DEI efforts? Do you have any experience dealing with that? I think at the top of the call, we discussed employee resource groups, employee affinity groups. What role should they play in this moment? Who wants to take that first?
I'm happy to start, and I'll lead. When thinking about affinity groups, I think this actually goes back to the theme that we talked about in terms of knowing thyself, and Kim talked about this as well, the risk tolerance, and just what's important within the organization. How are employee resource groups used? How are they used within the company? But if you understand your company, if you understand your employees, you can think about how you can ally in terms of how much information should be shared. I think that's subjective. Some of the things that we've talked about is some organizations highly value transparency and want to be transparent in every way possible. Other organizations find that there's a sweet spot of information that is appropriate and consistent to share. And some are far more conservative and really don't want to share anything, or will only do so when required. So I think it's that sort of blend of what is the right appetite for a particular company at that time, making all of those risk and cultural assessments. What's the idea? Some can think, when you think about transparency and trust, there could be a correlation with that. So some organizations are willing to share more information because the idea is to sort of build trust. So I think it's, again, somewhat subjective and very company specific. And then you also have to just think about also privacy regimes too when you're sharing data and what you can and cannot share.
Yep, I completely agree. And my personal bias is sharing as much as possible. I will always advise and guide for us to be able to share any organization I ever would be supporting. Because I think particularly right now, we're living in such challenging times. And in extending, like Vicky mentioned, the trust to your employees about issues that you're navigating as an organization. And acknowledging, you may not have the solutions to everything, but to be able to acknowledge challenges, I think does build a lot of trust. And I think it's about what type of culture are you sort of fostering. But I think that there is very much a way to be able to share as much as you possibly can while reinforcing your commitment to an inclusive and respectful and welcoming work environment. And so I like to think about it as we can't necessarily control what's happening outside in the world, but we very much can have a perspective and set the tone for expectation of what's happening within our organization. And extending trust to our employees helps with that. But we can confirm with our teams the values that we have, and that we very much want different perspectives around the table, because one opinion is going to be dwarfed every single time by 10 opinions that get you to the best solution, 10 opinions from varying backgrounds, which is another way to sort of get to diversity, right? Where did people come from? What did they do in their past? What are their life experiences? All very, very valuable things that are not prohibited by law to be considered.
Yeah, I mean, just picking up on Kim's last point, I think it's so critical for an employee base to understand why the organization is committed to diversity, and why it has certain diversity initiatives and goals, and why it is that leadership feels like a diverse team produces better outcomes, and really constantly having that conversation with your employee population so that they truly understand the why behind the initiatives, and don't just think, oh, this is, some sort of thing that they did in response to something, or this is performative, or even worse, this is something that's discriminating against me, as a, white straight male in this organization, because really all they care about is the promotion of like women and people of color. And I think like you can help blunt some of that by having like open and frank conversations about why diversity matters in the context of your organization and how it helps the bottom line. I mean, I was really struck by one of my clients who had flagged for me a couple of months ago that 50% of the allegations that came in on their whistleblower hotline in the span of a couple of months were all about criticizing, the company's diversity, equity, and inclusion initiatives as being discriminatory against them. It was 50% of the hotline, the whistleblower hotline allegations that came through. And I think a piece of this, after sort of talking them through sort of how to respond and what to do, was that the employees really didn't understand what the programs were, why they were necessary, who had rolled them out, what they really meant, like what it was, and that sort of lack of understanding can sometimes lead to people feeling like they're being marginalized, which from a legal perspective usually leads you into whistleblower allegations and lawsuits. So, I think all of these things are sort of interrelated, and the more communication around why diversity matters, why you're doing it, and why it's important to your organization will sort of help with those things.
No, that's super helpful. We are at about 2:18, and I think we've covered all of the questions. So and Damon had to step away, but I just wanted to give you my sincere gratitude on his behalf for your expertise, for sharing your expertise. I know that I've really learned a lot during this conversation, and I know that the expertise that you shared was so incredibly helpful for the folks who tuned in. I don't know if you want to share any closing remarks before I turn it back over to Kaylon.
I'll mention Darielle, because I was not a part of the first part of this, but I did review that and sort of preparing for this discussion. And what I would say in sort of closing remarks is that it's not the case, just to reinforce, that private employers need to halt diversity initiatives. And somebody in the first session mentioned, and I think it's worth mentioning again, that it is statistically true that historically underrepresented communities continue to be underrepresented in the highest paying jobs and are overrepresented in the lowest paying jobs. And so what I would challenge all of us is that leading in the face of adversity is one of the hardest things to do. As in-house counsel in particular, we, and along with our partner outside firms, but being in-house, you really have the opportunity to influence and to leverage outside counsel to help find solutions. And so we are facing adversity, advancing diversity right now. And now is the time to lead, and now is the time to double down, not to retreat. And I think together, working together, we can create really great work environments where people know that diversity is valued, and therefore they will want to be working for us, which I think sometimes is part of the battle.
Thank you, Kim.
Going to say I echo Kim, what she said, and I think that big picture perspective and having those pieces together and connected is incredibly critical, and also bringing in the different perspectives and partnerships on these issues, and sort of thinking outside in and being creative, and not necessarily always focusing on what should be, but thinking about what is and what could be, and thinking about the possibilities. Also, I just wanted to express gratitude just for this conversation today, the amount of conversations and the number of conversations on the issue. It truly takes a village, and just I think gratitude for all of the people coming from different perspectives just on an incredibly important issue, and bringing thoughts and minds and hearts together, to make for a better place.
Yeah, and just picking up on what Vicki said, just Darielle and Damon and Kellyanne, thank you all so much for organizing this conversation. And I think, look, the legal landscape here is going to continue to evolve. We'll all be watching a lot of these cases closely. But to the extent that I could sum up, everything that we talked about here, it's, you don't have to scrap DEI efforts. You just have to do them in a smart and thoughtful way, and sort of hand in hand with your business partners, HR partners, DEI partners who are responsible for implementation, to make sure that what you do is legally durable, but that does not mean back away. So.
Thank you so much. I'll turn it over to Kayla.
Thank you very much. So we would like to thank our esteemed panel for an amazing presentation. Thank you once again to the Lawyers Committee for Civil Rights Under Law for making this possible, and our continued valued partnership. So while on the subject of DEI, we encourage you to participate in the ACC Foundation DEI Maturity Assessment, which is powered by Ethisphere. This innovative resource takes the methodology used to evaluate DEI progress from the ACC Foundation Maturity Model and creates an online assessment tool that allows organizations to quickly and easily benchmark their DEI efforts to those of their peers and receive a written self-assessment generated by the module for your internal review. The best part is that the tool is offered as a free service by ACC Foundation for use by the entire legal and business communities. You can access it using the QR code on the screen or at the link that's in the chat. Thanks to all of you for your time and support of the ACC Foundation. This concludes today's webcast and this series. Please enjoy the rest of your day.